Not going to be giving a long interview. I am seated here today to give my ruling, my reasons for the rulings we have made in the presidential election petition, which was withdrawn recently. I instructed my staff to put my ruling here for delivery. The Chief Justice and the other members of the quorum have opted not to be part of this afternoon's proceedings, and I respect their decisions. However, what is of surprise to me is that my file has apparently been confiscated on the orders of the Chief Justice. I am going to proceed in the court building to recover my file, and I'll come back and read my ruling today as scheduled. The applications that were called, and then I'll call your application for my ruling. Thank you. Before I give my reasons, I wish to put on record the unfortunate developments of this afternoon, where the Chief Justice of Uganda has attempted to gag me by denying me the opportunity to read a ruling detailing my reasons for the decisions I arrived at in the petition that was withdrawn. As some of you who are here this morning know, the court convened with all the members of the quorum, and the Chief Justice directed that the rulings of the court would be read first, and then I would have an opportunity to read my ruling at the end. After the three rulings were given, the Chief Justice, who is the head and has been the head of the quorum, announced that the court was taking a recess and that we would return in 30 minutes. To my surprise, when we convened after the break, I was informed by my colleagues that they could not join me to read my ruling, as I had done when they were reading the majority ruling. The reason they advanced is that I had not circulated my ruling for them to review. And my response was that we arrived at the decisions in all the rulings. We already arrived at our decisions. We already made the rulings. What is contained here are the reasons why we made the rulings that we made. While it is good practice for a member of the court to circulate their draft ruling to colleagues, there is no law in Uganda that I'm aware of that requires me to do so. I would have loved to circulate my draft to my colleagues before, but as you heard from the rulings, the 45 days that the Constitution requires us to finalize this matter constrained my ability to do so. Nevertheless, the whole court was aware of my decisions in each of the three applications that were called today. So I'm very surprised that the Chief Justice of Uganda has chosen to use barbaric means and to use his powers in the manner that he has chosen to do so. The Chief Justice had further directed me that my ruling will be read at a later date, that he would choose to appoint, and after he and the other members of the quorum had probably vetted my ruling. I found that order unconstitutional, and I chose to disobey it. When I was appointed a judge of this court in 2009, I swore to uphold the Constitution of Uganda, and I also took the judicial oath. And I am acting based on those undertakings I made. I felt it my constitutional duty to disobey the orders, the unlawful orders of the Chief Justice, and to fulfill my duty as a member of this quorum to deliver my decision within the 45 days that are required under Article 104. With those remarks, I will now proceed to read, in summary, my consolidated reasoned rulings. The petitioner, or before I go to that, of course, on the directives of the Chief Justice, he ordered that all the microphones be switched off, that this tent should be closed, and I want to thank those who gave me directions to an open entrance. But even with this court being closed, this tent, which we turned into a court being closed, I was ready to read my ruling under the mango tree shade. So with those opening remarks, I want to now proceed with reading my ruling. The petitioner, Kyagulanyi Ssentamu Robert, herein referred to as Kyagulanyi, filed this petition on 19 February 2021, challenging the outcome of the presidential elections that were held on 14th January 2021. He filed the petition against A, the first respondent, Yoweri Museveni, Chibuhaburwa Kaguta, herein referred to as Museveni, who was declared the winner of the 2021 presidential election, the Electoral Commission, herein referred to as the Electoral Commission, and C, the third respondent, the Attorney General, herein referred to as the Attorney General. I've talked about the representation of the parties by their lawyers, and I will not read it. Background. The background to this petition is that Kyagulanyi contested with 10 other candidates in the 2021 presidential elections. The elections were organized by the Electoral Commission and were held on 14th January 2021. On 16th February 2021, the Electoral Commission declared that Museveni had obtained 5,851,037 votes in the 2021 presidential elections, which amounted to 58.64% of the total valid votes that were cast in the said elections. The Electoral Commission then declared that Museveni, having obtained the highest number of votes and more than 50% of the valid votes cast, had won the 2021 presidential elections. The Electoral Commission also declared that Kyagulanyi had obtained 3,475,2 298 votes, which amounted to 34.83% of the total valid votes cast. The Electoral Commission further declared that the remaining 8 candidates obtained the following votes and percentages. I will not go over them. Kyagulanyi was aggrieved by the declaration by the Electoral Commission of Yoweri Museveni as having won the 2021 presidential elections. On 1st February 2021, he filed presidential election petition number 1 of 2021, in which he made the following allegations. 1. That the elections was invalid on grounds that it was not conducted in accordance with the principles laid down in the provisions of the Constitution of the Republic of Uganda, the Presidential Elections Act, the Electoral Commission Act, bear with me, other relevant laws, and that the non-compliance affected the results in a substantial manner. 2. That the election was invalid on grounds that offences under the Presidential Elections Act were committed by the first respondent or with his knowledge and consent or approval, and that the entire electoral process was characterized by security agencies, in brackets UPDF and UPF, committing acts of murder, causing grievous harm, violence, abduction, and intimidation against the petitioner. On 9th February 2021, I joined my colleagues on the quorum hearing Presidential Election Petition number 1 to disallow Kyagulanyi's application seeking leave to amend his petition to this court, where he had challenged the declaration of Museveni as the validly elected president in the elections that were held on 14th January 2021. I have since had the opportunity to read in draft the majority ruling of this court, giving the reasons why Kyagulanyi's application for amendment was not allowed. With all due respect to my colleagues, I do not agree with some of the reasons for the decision I arrived at with respect to the application for amendment of the petition. I'll begin with the law. I entirely agree with my colleagues that the law governing presidential election petitions in Uganda is found in Article 104 of the Constitution of Uganda, Section 59 of the Presidential Elections Act, and the presidential election (election petition rules) made thereunder. Article 104 provides in the relevant part as follows. I will not read it in the interest of time. On the other hand, Section 59 of the Presidential Elections Act also provides for challenging the outcome of the presidential election in similar terms as Article 104 of the Constitution. I have not found it necessary to reproduce it here, with the exception of subsection 111, which provides thus: the Chief Justice shall, in consultation with the Attorney General, make rules providing for the conduct of petitions under this Act. It's clear from the above provisions that both the Constitution and the Presidential Elections Act require the following. 1, that a petition challenging the outcome of a presidential election should be filed by any candidate who is aggrieved with the result declared within 15 days from the date the challenged results were announced. In this particular case, the results of the 2020 presidential election were declared by the Electoral Commission on 16th January 2021. 2, that once a petition has been filed, the court should expeditiously inquire into and determine it and give its reasons for its findings not later than 45 days from the date the petition was filed. 3, the Presidential Elections Petition Act gives power to the Chief Justice in consultation with the Attorney General to make rules providing for the conduct of petitions. Turning to this particular application, it's not disputed by all the parties that Kyagulanyi, the petitioner, filed his presidential election petition on 1st February 2021. In their pleadings, some of the respondents contended that Kyagulanyi's petition was bad in law because it was filed after the expiry of 15 days from the date the election results were announced. It's indeed true that 1st February, when the petition was filed, was beyond the 15 days after the declaration of the presidential election results. However, it's also worth noting that the last day of the 15 days fell on a Sunday, which is not a working day. Secondly, the Chief Justice had not yet given directions for the record registry to be open on Saturday and Sunday, as is mandated under Rule 12(2)(c) of the Presidential Election Petition Rules. Nevertheless, in this case, the Chief Justice directed that the filing could be done on a Monday, 1st February 2021, and the petition was accordingly filed in court on that day. During the hearing of the application for amendment, Counsel for Kyagulanyi relied on the following provisions of the law stated in the notice of motion. I will not read them. Relying on the provisions, Counsel for Kyagulanyi contended that the provisions give power to the court to allow his application. He further relied on the following grounds briefly stated in the same notice of motion. One, that the applicant filed a presidential election petition on 1st February and served it on the respondents. 3, I'm skipping some of that filing of two, that filing of pleadings in the petition was still ongoing. 3, the amendment to the petition is necessary to enable this court to effectively investigate and completely determine all questions involved in the petition. 4, that the respondents shall not be prejudiced by the amendments to the petition. 5, that the proposed amendment to the petition did not raise a distinct cause of action in the place of the original. 6, that both the original petition and the proposed amended petition concern the same claim of right. 7, that it is in the interest of justice, equity, and fairness that the applicant be granted leave to amend his petition. Kyagulanyi's application was further supported by his own affidavit and an affidavit by his advocate, Tuliasima Gwaffe, and 2 supplementary affidavits sworn by him. In his affidavit of 8th February 2021, Kyagulanyi repeated the grounds in his notice of motion and further deponed as follows, and I've laid out what he said. In the said affidavit, Kyagulanyi deponed as to the reasons why he was seeking an amendment to his petition. The supporting affidavits of his counsel, Tuliasima, also deponed to the same facts and the fact that counsel could not access Kyagulanyi at his home for 10 days after the election results were declared by the Electoral Commission. He relied on the decision of this court in Amama Mbabazi versus Yoweri Kaguta Museveni and 2 others, where this court allowed the petitioner to amend his petition. He also relied on other decisions of this court, which have. The applicant further relied on Rule 22, 44, 42 and 44 of the Supreme Court rules. I've not found it necessary to reproduce these rules. This is because Rule 21 of the Supreme Court rules provides that they shall apply only to appeals from the Court of Appeal. All the 3 respondents, Museveni, Electoral Commission, and the Attorney General, strongly opposed this application. Relying entirely on non-Ugandan decisions, the respondents contended that the Constitution does not allow for amendment of an election petition outside the 15 days a petitioner is allowed to file. Secondly, they contended that although the applicant's movements had been restricted for 10 days, he still had access to his lawyers. Thirdly, they contended that Kyagulanyi's restrictions did not affect his ability to instruct his lawyers to prepare and file his petition. Fourthly, they opposed the application on grounds that the amended petition was introducing a new cause of action, that is the alleged lack of qualifications of Museveni, the winner of the elections, to stand for and to be elected as the President of Uganda. I have noted in the majority ruling of this court that they agree with the submissions of the respondents. With all due respect to counsel for the respondents and my colleagues on this quorum, I do not subscribe to the alleged legal position that a presidential election petition cannot be amended after the expiration of 15 days following the declaration of those results. As I noted earlier, all the respondents conveniently ignored the binding precedent of this court over Mama Mbabazi, where we allowed the petition to be amended. The respondents did not canvass this issue, nor the issue why the court should not follow this earlier precedent. While it is true that Article 104 of the Constitution and Section 59 of the Presidential Election Petition do not expressly provide for amendment of the petition, none of the said provisions expressly bar this court from allowing amendments. In the past, this court has jealously guarded the jurisdiction conferred on it by the Constitution and refused to allow arguments by parties praying to the court to hold that its jurisdiction was ousted. And I give an example of a case where this court declined 201 former employees of 4GS Security Services. This court declined to find that the jurisdiction of the High Court to handle employment matters had been ousted by the Industrial Court, which had not yet been set up for 5.5 years after the law was enacted. If this court declined to do so in a case where the law specifically provided otherwise, I would not subscribe to a view that this court's power to grant leave in proceedings before it could be ousted by a mere deduction that the power to amend is not expressly provided for. This court has always upheld its inherent jurisdiction to do justice to all parties as the circumstances of the case before it would warrant. In summary, I state that that is not one of the reasons I disallowed this application. Thirdly, the applicant also relied on Section 98 and 100 of the Civil Procedure Act, Rule 15 of the Presidential Election Petition Rules, and Order 6, Rules 19 and 20 of the Civil Procedure Rules. With the exception of Section 100, I found the remainder of these provisions applicable. Of particular interest is Order 6, Rule 9 of the Civil Procedure Rules, which specifically vests in this court power to allow a party to alter or amend pleadings, his or her pleadings. The rule provides as follows, and I've quoted it. The rule was applicable to a presidential election petition by virtue of Rule 15 of the Presidential Election Petition Rules, which provide that the Civil Procedure Act and rules made thereunder shall apply to presidential election petitions with such modifications as may be necessary. It's however important to note that while this court had the authority to allow the applicant petitioner to amend his petition, Rule 19 uses the word may, thereby giving the court discretion to grant or not to grant the application to amend. I will now turn to the issue of whether or not the application should not be allowed, because the proposed amendments would be introducing a new cause of action. The respondents contended that the proposed amendments of the petition, which was introducing the issue as to whether or not Museveni had the necessary qualifications provided for under the Constitution to be elected President of Uganda, was introducing a new cause of action after the expiry of the 15 days limitation period for filing a presidential petition. It is trite that the issue of persons who are eligible to stand for election as president is a matter of law. These qualifications are spelled out in Article 102 of the Constitution and repeated in Section 4 of the Presidential Elections Act. Section 102 provides as follows, and I have quoted the article, you can access it. On the other hand, Article 104 gives the right to an aggrieved candidate to petition the Supreme Court on grounds that the person who was declared as the winner of the elections was not validly elected. That being the case, the cause of action granted to an aggrieved candidate is to bring an action challenging the validity of the election of the successful candidate. I therefore do not agree with the respondents and the majority justices of this court that by the petitioner raising the issue of qualifications of Museveni, the winner of the 2021 election, or lack thereof, he was seeking to introduce a new cause of action. Contrary to the respondents' contentions and the majority of the court's view, I believe that the issue of qualifications of the President is not subject to the 15-day limitations rule. A petitioner or even any other person could have raised this issue before the presidential election was held or even after the elections are completed. In my view, a challenge to the qualifications or disqualifications of a presidential candidate cannot be extinguished on the basis of Article 104. Having been provided for in a separate article, it was my view that the petitioner did not, it is my view that the petitioner did not need to amend his petition. I'm aware of the provisions of Section 59(6) of the Presidential Elections Act, which provide as follows. 6. The election of a candidate as president shall only be annulled on any of the following grounds if proved to the satisfaction of the court. And B, 1 is non-compliance with the provisions of this act. If the court is satisfied that the election was not conducted in accordance with the principles laid down in those provisions, and that the non-compliance affected the results of the election in a substantial manner. B, that the candidate was at the time of his or her election not qualified or was disqualified for election as president. C, that an offense under this act was committed in connection with the election by the candidate personally or with his or her knowledge and consent or approval. I note that Parliament was granted power under the Article 104 of the Constitution to, quote, make such laws as may be necessary for the purpose of this article, including laws for grounds of annulment. Pursuant to this section, Parliament enacted Section 59(6)(b) quoted above. Although Parliament was acting within the powers granted to it under Article 104(9) of the Constitution, the inclusion of the ground of annulment in Section 59(6)(b) without referencing Article 102 of the Constitution from where it is derived led the unfounded view held by the respondents that a successful presidential candidate's qualifications can only be challenged under Article 104 of the Constitution and Section 59(6) of the Presidential Elections Act. I hold the view that a constitutional challenge based on the lack of qualifications of an elected president, as provided for under Article 102, can be made, 1, before the election is held, 2, during the presidential election petition filed under Article 104(1), or at any time after the 15 days have lapsed, 15 days under Article 104 have lapsed without a petition being lodged in the Supreme Court, or 4, after the conclusion of a presidential election petition. It goes without saying that such a challenge is not brought within, such a challenge which is not brought within an Article 104(1) petition could be brought under Article 137 of the Constitution. I'm aware that my views above differ from the ruling of the court in this application, in which I concurred and where we unanimously ruled as follows with respect to this issue. Court finds that the issue of qualifications of the first respondent in the proposed amended petition is a new matter which comes outside the limitation period for filing a presidential election petition. Therefore, we disallow it. Having critically reviewed the constitutional provisions I have cited above, I have come to the conclusion that I arrived at a wrong decision to rule as above. While this is so, I'm aware that Article 132(4) of the Constitution gives this court a right to reverse itself in appropriate cases. It provides as follows. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. I'm further aware that although this right is vested in this court as a whole, this article does not exclude the possibility of a single justice of this court to depart from a position he or she has taken earlier. This is especially so in a case like this one, where there is a decision of the whole court and where therefore there is no option for a reference from a decision of a single justice, as is in the case in the other cases where the court is exercising its appellate civil and criminal jurisdiction. Other than the above, I stand by the rest of the ruling of the court rendered on 4th February 2021. Having listened to the submissions of the applicant, I was convinced that he had made out his case that the restrictions on his movement by members of the police and army had adversely impacted on his ability to instruct his lawyers and to also prepare for his petition. I was further convinced that the applicant had been, quote, arrested in his house for 10 days by the police and the army, thereby losing 10 critical days out of the 15 days he was granted under the Constitution to lodge his petition to this court. The averments of Kyagulanyi and his counsel were validated by the order of the High Court issued in Kyagulanyi Sentamu Robert and Barbara Kyagulanyi Tungo versus Attorney General, Chief of Defense Forces and Inspector General Police, High Court Miscellaneous Cause number 16 of 2021, where Elubu J ordered as follows. 1. The restriction imposed on the applicants are unlawful and their personal liberty be hereby restored. 2. The applicants comply with the COVID-19 SOPs. And 3. The respondents pay the cost of this application. Although I was convinced that the applicant had made out his case for amendment, I was convinced that the non-amendment of his petition would not necessarily be fatal to his case. A review of his petition showed that although he was constrained to prepare and file his petition in only 5 days, instead of the 15 days he was constitutionally entitled to, he had managed to plead the non-compliance with the principles set out in the law and that Museveni, the winner, had committed electoral offences. As I pointed out earlier, either or both of the grounds, if proved, would be sufficient for this court, after concluding its inquiry into the petition, to make any of the orders it is permitted to make under Article 105 of the Constitution and Section 59(6)(b) of the Presidential Elections Act. The second reason related to the remaining proposed amendments. Having reviewed them from the copy that was attached to the application, I concluded that all those matters could be brought in within the petition as evidence. The third consideration that I took into account was the constitutional dictate in Article 104 of the Constitution for this court to conclude its inquiry and to make its decision not later than 45 days from the date of filing the petition. Although I was convinced that this obligation did not require the court to refuse a deserving amendment, any time saved by the court without prejudicing the parties would be in the interests of both parties, as it would give the court more flexibility to manage the hearing, inquire into the petition, and to render its decision. I will now proceed to read my reasons for allowing Kyagulanyi's application for extension of time to file his evidence in support of his petition. In 2021, Robert Kyagulanyi made a formal application for extension of time to file the remainder of his evidence. He filed miscellaneous application number 4, seeking for the following orders. 1. The time granted to the applicant for filing additional evidence in support of the petition be enlarged by 1 extra day to enable him file and serve all his compiled affidavits. 2. The respondents be given some extra days to file responses. 3. Costs of this application be provided for. On 19th February 2021, this court, by a majority of 8 dismissed the application while allowed it for the following reasons. The application was supported by the affidavit sworn by Kyagulanyi and was based on the following grounds laid out in the notice of motion. One, that the applicant filed the instant presidential election petition on 1st February and served it on the respondents. 2, that the filing of pleadings in this petition is still ongoing. 3, the filing of the additional affidavits in their petition is necessary to enable this honorable court effectively inquire into and determine all questions involved in the petition. 4, there are prevailing special circumstances that warrant the grant of this application. 5, the applicant has brought this application without any delay. 6, that the respondents shall not be prejudiced by extra time being granted to the petitioner to file and serve the additional evidence in the petition. And 7, that it's in the interests of justice, equity, and fairness that the applicant be granted extra time to file and serve the additional evidence in the petition. The application was supported by the affidavit of Kyagulanyi, where he listed the following additional grounds. And I'll just highlight that on 14th January, upon casting my vote in the general elections, I went back and interacted with our party officials on the progress of the elections, but around 1 p.m., I noticed that my telephone signals had been disabled. 3, that when I and my family woke up the following morning of 15th January, our home had been surrounded by the police and military personnel, effectively placing us under house arrest for the next 10 days. 6, that I'm reading that when I attempted to move out of my home to seek for legal advice from my lawyers and the decision of my party leadership organs on the next course of action, the police and military officers that had surrounded my house refused me from doing so. And there are many reasons which are reproduced here in his affidavit. I will not read all of it. Paragraph 30, that I will start with. I'll start with 29. That consequently, the decision from the Chief Justice through the Land Registrar was to the effect that, save for the evidence in 13 copies of Volume 2, out of which 7 copies had been received by 5 p.m. on 14 February 2021, the other copies of evidence would not be received, thus leaving the additional affidavits of evidence under Volumes 3, 4, 5, and 6. Copies of indices of the affidavits in Volumes 3, 4, 5, and 6 are herewith attached and marked as annexures E, F, G, and H. Paragraph 30 read that I immediately instructed my lawyers to file this application. But on 16 February, having been a public holiday, they told me that they would file the same on the following day of 17 February. Paragraph 32 read that the additional evidence I obtained from about 200 witnesses across the country is necessary to enable this honorable court effectively inquire into and determine all questions involved in the petition in the first respondent and the third respondent. B, it reveals how results declared by the second respondent were falsified in favor of the first respondent. C, it brings to fore the various cases of robbery committed by the first respondent and by his agents. D, it brings to fore the circumstances under which the independence of the second respondent was compromised by the authority of the first respondent abusing the power of incumbency. E, it portrays the audio-visual expression of how the agents of the third respondent selectively enforced the electoral guidelines and used excessive force to frustrate the petitioners' election campaigns in favor of the first respondent. F. It brings to the fore the instances of voting in the names of deceased persons and persons out of the country. G. It brings to the fore how the second respondent relied on an incomplete, improper, and incoherent voters' register in the election. H. It brings to fore how the second respondent unlawfully, inefficiently, and covertly deployed a biometric voter verification kit, brackets BVVK, and electronic results transmission and dissemination technology system, in brackets ERDTS, without access by the petitioner and denying him the right to verify voters and audit the results. I. It brings to the fore how the petitioner's stronghold districts / cities of Kampala, Wakiso, Mukono, Mpigi, Gulu, Masaka, and not the first respondent stronghold districts of Kiruhura, Isingiro, Bunyangabo, Kazo, Kamwenge, Kyankwazi, were the epicenter of intimidation and violence against voters, and how this affected the percentage voter turnout in favor of the respondent as against the petition. 33 avert that I state that there are prevailing special circumstances that warrant the grant of this application. And in 34, he averred that leaving out the evidence sought to be adduced would assist the first respondent to commit electoral wrongs and get away with it, which has a significant impact on the peace, stability, and democracy of our country. And then he also pleaded that I have made this application without any delay in the circumstances of this matter. And lastly, that it is in the interest of justice, equity, and fairness that I be granted leave to file this evidence. The application was also supported by the affidavit of Wamedi Anthony, and I will not go over it, but I've reproduced it. Museveni opposed the application. In the affidavit of application is brought in bad faith and an attempt to mobilize the public organs against this court, and is an abuse of the process of court. And then he also pleaded that I'm advised by my lawyers that the affidavits of the applicant are allegedly so detailed that the remaining time before trial is not reasonably adequate for the second respondent to comprehensively answer, and would be prejudicial to the second respondent and will amount to a miscarriage of justice. In paragraph 24, he pleaded that there are no special circumstances to warrant the grant of this application, and that he swears this affidavit in resolute opposition to the instant application. The Electoral Commission also filed a second affidavit by Bahige, David Mutume, and I will not read it in the interest of time, but it's introduced. The Attorney General also opposed this application and relied on the affidavit of Alan Mukama, and he also deponed on the matters which I've reproduced here. But in order for extension of time, even though this was an election matter. The applicant further relied on Section 100 of the Civil Procedure Act. In my view, this section was not applicable. However, under Section Orders 51, Rule 6 of the Civil Procedure Rules, there is power to enlarge time, and Rule 5 of the Supreme Court rules provides for power to enlarge time, but Rule 15 of the Presidential Election Rules does not mention the above rules, and it would be improper for me to import them here. The applicant further relied on Rule 2.1 of the Judicial Supreme Court rules, and again, I think as I mentioned earlier, they are not applicable. File and serve their pleadings as the case may be, and the court has issued new timelines accordingly. The practice of counsel practicing before this court of not adhering to timelines provided for in the law and in the Judicature Supreme Court rules and or directions given by the court is regrettable, and I condemn it. However, the court in previous cases where counsel failed to abide by the set timelines, this court has opted not to penalize the parties for their counsel's failure to meet the either statutory or court-ordered timelines. Instead, having in mind the overriding constitutional principle enshrined in Article 126E of the Constitution, the court has accepted these documents filed out of time, even on the day of the hearing, or adjourned the cases to another date to hear the parties. The rationale of accepting these documents, instead of declining to grant extension of time to file and serve pleadings not served in time, has been to provide the court the opportunity to render substantive justice to the parties by ensuring that the matter in dispute is disposed of on its merits and not on technicalities. In Uganda versus Ntambi, Mwangusha J dismissed an application seeking leave to file a notice of appeal 8 months after judgment had been delivered. I entirely agree with the decision. However, in the case at hand, the record shows that after missing the deadline to file and serve the applicant's counsel took action in less than 12 hours to ensure that the evidence is received, and took a day and a half to make the formal application for extension of time. It's worth noting that the intervening period was a public holiday, in essence, leaving only half a day to take action. I cite some cases here. A decision in Moletori Nawe, and another decision to Shabe Chris, where Nshimye J observed as follows, quote, "The law creates gates of justice through which people seeking justice pass to reach courts to be redressed. The gates open and close at given intervals in accordance with the rules of procedure. In rare circumstances, gates which are closed may be opened to allow in a late entrant. The application to open or not open is vested in the court. The application before me is one of such rare late coming, restriction unlawful, leaving him with only 5 days to prepare for his petition and evidence to support his petition. The restriction of his movement was done by members of the security forces and could not have been done without the direct consent and or knowledge of the first respondent, who is not only the president-elect, but also the commander-in-chief of the armed forces, and who appointed the current chief of defense forces and the inspector general of police. Similarly, by virtue of his term of office, he is continuing to remain in office pursuant to the remaining term of office until he is sworn in. The president-elect, as head of the executive arm of government, must have been the one who moved the amendments my other copy had the edits now, of the time from 10 days to 15 days pursuant to the recommendations of the Supreme Court. The Attorney General was the chief, who is the chief government advisor, tabled the Constitutional Amendment Act and the Presidential Election Amendment Act in Parliament less than 1 year ago. I was very surprised that he could stand up in court and claim that an aggrieved candidate who only had 5 days to prepare and file his petition and present his evidence had not been affected by the restriction. Secondly, the argument by the respondents that the period of restriction the court had declined to allow the amendment of the petition, and therefore that the 10 days restriction was irrelevant to this application was misconceived by all the three respondents. When the court declined to grant the application for amendment, the court did not give its reasons, and therefore it is not right for the respondents to anticipate court's reasons for declining to grant. It was not right to anticipate the court's reasons for declining to grant the application, and therefore, and to argue as they did. The Attorney General, who was opposing the application, sorry, I will skip this. The applicant's counsel was cognizant of the constitutional mandate requirement for this court constitutional obligation to give its findings and decision within 45 days under Article 104(3) of the Constitution. In his submissions, counsel for the applicant was ready to concede 2 days of their rejoinder to the respondents, cognizant of the mandate of Article 104 and Section 59(3) of the Act. Indeed, it is true that the enlargement of time for the application to file additional evidence would have had an impact on the roadmap, which had been released earlier and which would require the respondents to file additional affidavits in rejoinder of any new matters not taken care of in the affidavits they had filed earlier. But while this is so, the respondents, and indeed the majority, opted to ignore the fact that when these provisions were enacted and the Constitution was promulgated and amended, no one envisioned a situation where a president-elect, who is also the incumbent president, would act through the various organs of state under his control and incapacitate an aggrieved candidate by restricting his movements for 10 days. Therefore, courts should have been cognizant of the fact that while Article 104(3) of the Constitution and Section 59(3) of the Presidential Elections Act required courts to declare its findings within 45 days from the date a petition is filed, this requirement did not impose on the court a duty to ignore the unconstitutional and unlawful acts as declared by the High Court to the detriment of the applicant. The restrictions of the movement on the movement of the applicant as pleaded in his affidavit and as confirmed by court more than constituted the special circumstances which were envisaged under Rule 17 of the Presidential Elections Rules. It is my firm view that the court could have allowed the application to file additional evidence which was ready on the morning of the 15th February 2021, when the deadline for filing was 5 p.m. on 14th February 2021. The applicant partially complied by filing part of the evidence on that date. even if they were not able to file the rest by 5 p.m., the fact that they were ready with it on Tuesday, 15th, confirms the applicant and his counsel's averments in their respective averments that the other volumes were ready. I take judicial notice of the fact that the country is under curfew, and the time of the deadline of 5 p.m. On 14th, the time between the deadline of 5 p.m. on the 14th and curfew time of 9 p.m. would not have been sufficient for the applicant and his counsel to produce the number of affidavits in the volumes required. On dilatory conduct, there is a long-standing principle that has been upheld by numerous decisions of this court that mistakes of counsel should not be visited on their client. The applicant's counsel was not able to deliver all the evidence in the time prescribed for a variety of reasons, some of which were submitted on by counsel Segona. By the majority attributing the mistakes of counsel on their client, the court was reversing its decisions without giving reasons. I'm aware that by the time the court issued the roadmap requiring the applicant to file his evidence not later than the 14th of February, the applicant had had the benefit of the 14 days from the time he filed his petition. But that notwithstanding, the blame that was heaped on him for failure to have produced evidence earlier is misconceived, because it's an undisputed fact that he had lost 10 days of preparation time at the instance of the executive, currently led by the first respondent as the incumbent, and who had the capacity to give orders or to cancel them. I also wish to note that this application was heard on 19th February 2021. The application was filed on 17th February 2021, and the applicant gave his reasons for not filing earlier because they were waiting for court's response, which came in at 6 p.m. and the following day was a public holiday. Rule 12(2) of the Presidential Elections Petition Rules mandates this court, in accordance with the dictates of Section 59(3), to inquire into and determine the petition expeditiously. The hearing of this application could have been brought forward than was the case. The applicant cannot be blamed. The delay cannot be blamed on the applicant because he was not responsible for fixing the hearing of the application. In our ruling for disallowing the application for amendment, the court specifically acknowledged that the applicant's petition had grounds, but what was required was the evidence to supplement those grounds. From the application, the applicant was only requesting for 1 day to file and serve additional evidence, which was ready on the morning of 15th, just 12 hours after the deadline. It's not disputed that the applicant did not file all his evidence in the time he was required to, as per the roadmap or as per the orders. That's 5 p.m. on 14th February. But it's also evident from the record that the applicant partially complied with the orders and made genuine effort to file his evidence before the deadline expired. And as I've said, this can be deduced from the fact that though they were unable to file the applicant's evidence by the deadline, they were ready with the rest of the evidence in the morning by 7 a.m. on 14th of February. I do not condone the the conduct of the counsel for the applicant or even the applicant for failure to comply with the directives of the court. That notwithstanding, I'm cognizant of the fact that litigants and their counsel have not always complied with the orders given by the court in matters currently pending before this court. The applicant was acting with the Constitution. Of the Constitution entrenches the right to personal liberty of all Ugandans. Furthermore, Article 28 also entrenches the right to privacy of a person. In light of these clear provisions of the Constitution and the absence of any evidence tendered by the third respondent falling in the exceptions permitted under Article 23 and 27, and the decision of the High Court, it behoves my mind that the Deputy Attorney General could rely on evidence gathered from unconstitutional and unlawful conduct of state agents. But even more importantly, that these provisions are granted to all Ugandans. But in this particular case, what was at stake was not just individual rights that are protected. The applicant, having been a former presidential candidate, the petition he was pursuing was a matter of national importance because it has serious implications for democratic governance and the rule of law for this country. I also took note of the locking up of the party's offices and that the internet was locked down for several days. The respondents argued that some of the witnesses, the respondents disputed the evidence that some of the applicant's witnesses were locked up and contended that the applicant should have produced the list of witnesses in person. The list of witnesses of persons who are in prison. And since they did not produce it, they stated that the evidence should not be believed. With due respect to submissions of counsel for the respondents, I found no merit in their contentions. The applicant knows his witnesses from whom he needed statements and evidence, and where he needed to access them to obtain evidence to bring to court in support of his application. The affidavit. So the respondents were deponing to matters which were not within their knowledge, as they had no basis for refuting the applicant's claims that the applicant witnesses were indeed locked up in prison. Prejudice to the respondents. I need to comment on the contentions which were made by the respondents regarding the prejudice they would suffer if this application was granted. It was very disingenuous on the part of all the respondents to plead that they would all be prejudiced if the court extended the time for the applicant to file and serve the remaining affidavit evidence. He was not able to. The second respondent is a constitutional commission with nationwide offices throughout the country. Similarly, the Attorney General also has nationwide offices. In the petition, he was also representing the different organs of state, such as the police, the army, all who have offices throughout the country. It did not make any sense to me for the respondents to contend as they did that they required their witnesses to be in Kampala for them to file their respective responses to the additional evidence the applicant wanted to file, as opposed to these witnesses remaining at their duty stations whenever they may be, and where any other documentary evidence in rebuttal of the petitioner's applicant's evidence or claims would ordinarily be kept. But if the respondents' arguments are to be believed, it should then have been obvious that the applicant, whose movements and liberty were restricted, was even more affected and prejudiced in the preparation of his petition and evidence and its the presentation of his evidence in court. All counsel for the respondents castigated the conduct of the applicant and counsel in the conduct of his case. For the reasons that I've read above, I found that based on the law I have cited, this was a fit and proper case where the application should be granted, and I granted it. I'll now proceed to reasons for allowing Kyagulanyi's application to withdraw his petition. Section, I will not say much because this application was considered to 1(4) of the Presidential Elections Act provides that if a petition is withdrawn, the petitioner shall be liable to pay the costs of the respondent. This is also provided for in Rule 27 of the Presidential Election Rules. Arguing on behalf of Kyagulanyi, Counsel Segona urged this court not to make any order as to the costs against his client. On the other hand, all the three respondents prayed for the costs of the withdrawn petition to be awarded to them, respectively. With all due respect to the submissions of counsel for the respondents, I disagree with their submissions that the court should award the respondents costs for the following reasons. First, I find that both Section 61(4) of the Presidential Elections Act and Rule 27 of the Presidential Election Rules are unconstitutional. By enacting Section 61(4) of the Presidential Elections Act, Parliament assumed a judicial function when it attempted to legislate the award of costs to a withdrawn petition to the respondents. Article 104 of the Constitution vests in this court jurisdiction to hear a presidential election petition filed by an aggrieved candidate. The article also vests in this court jurisdiction to inquire into and determine the petition and to declare its findings and reasons. After Article 1045 provides that after the court has duly inquired into the petition, it can either dismiss it and declare which candidate was validly elected, or annul the election and order a new election to be held. The power of Parliament with respect to a petition filed is drawn from Article 1049 of the Constitution, which provides as follows, and I've quoted. This sub-article of the Constitution gives Parliament limited powers as are spelled out in it. It does not, in my view, give Parliament power to exercise a judicial function to award costs to the respondents in case a petition is withdrawn. It's straight law that the award of costs is a judicial function which should be exercised judiciously. The Constitution was very explicit about the source of judicial power. Article 126(1) vests that power in the judiciary as follows. Judicial power is derived from the people of Uganda and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with the laws and with the values, norms, and aspirations of the people. Furthermore, Article 128(1) of the Constitution also explicitly entrenches the independence of the courts. It specifically prohibits the courts from being subjected to the directions of any person or authority. Furthermore, Article 128(2) also directs that no person or authority shall interfere with the courts in the exercise of their judicial functions. The Constitution also entrenches the doctrine of separation of powers. Having provided as above with respect to the judiciary, the Constitution also entrenched the independence of Parliament in Article 79. It goes, and I've reproduced it, it goes without saying that the powers granted to Parliament under this article do not extend to making a law directing payment of costs to a respondent in case a presidential election petition is withdrawn. Besides Article 79, Article 50 of the Constitution, 1 of the Constitution, also vests power in Parliament to make laws relating to the judiciary. And it provides as follows. Subject to the provisions of this Constitution, Parliament may make laws providing for the structures, procedures, and functions of the judiciary. I'm also aware that counsel for the petitioner applicant did not raise this issue, and all counsel for the respondents did not have an opportunity to canvass this issue as well. However, I take the view that where the court, in the course of hearing a matter brought before it, it finds a provision of law contravenes the Constitution, it has a duty under Article 2(1) and 2(2) of the Constitution to declare it void to the extent of the inconsistency. In my view, this court is under no obligation to refer such a matter to the Constitutional Court, as it would only be applying the Constitution and not seeking for its interpretation. In Magombe versus Uganda, I stated as follows on this issue. Article 2(2) is a dictate of the Constitution. It does not give, in so doing, expected the court not to interpret the Constitution but to apply its provision. I still stand by the same views. So for the reasons I have advanced above, I find that I'm not bound to order Kyagulanyi to pay the respondents the costs of the withdrawn petition. The unconstitutionality of Section 61(4) of the Presidential Elections Act would by itself be sufficient to dispose of the respective parties' prayers on costs of this application and of the petition as a whole. That notwithstanding, I'm of the view that there are two other alternative grounds that support not awarding costs to the respondents. The first is that Section 61 and Rule 27 are declaratory and not mandatory. The operative provisions would have been Section 27 of the Civil Procedure Act, which I have quoted. Unlike Section 61(4) of the Presidential Elections Act, this section rightly preserved the discretion of a presiding judge to either award or not to award costs to a successful party. Hence, this section meets the constitutional test as it preserves the discretion of the presiding judge. But the more fundamental reason for declining to award costs to the respondent in this case is the issue of justice and fairness. The respondents argued that in the previous election petitions, this court has handled in 2001, 2006, and 2016, the petition was heard. They contended that this fact distinguished those cases where each party was ordered to pay their own costs from this one which was withdrawn. As I discussed earlier in this ruling, the respondents' prayer for costs to be awarded to them completely misses out the bigger picture about the nature and importance of a presidential election petition in our democratic governance. In Kano Kizza Besigye versus Museveni, Yoweri Kaguta and the Electoral Commission, election petition number 1 of 2001, Odoki, Chief Justice, articulated this as follows. This is not an ordinary case, but an important case involving the election of the President of the Republic of Uganda. It raises serious constitutional and legal issues, the answers to which and the reasons therefore need to be elaborately articulated for future guidance. The effect of the decision on the governance and development of the country and on the well-being of the people of Uganda cannot be overemphasized. Similarly, Justice Mulenga also expounded on this issue in similar terms. This court has established a practice of not awarding costs in presidential elections petition. There was therefore absolutely no basis for Parliament to stray into judicial territory and to make an unwarranted, predetermined distinction between withdrawn petitions and those that are fully heard. The established judicial practice in this country is not to encourage parties to continue pursuing litigation for the sake of it. Section 61(4) would seem to encourage that and also legislatively penalize in advance a petitioner who brings a petition to this court in good faith, but realizes midway through the process that it makes sense for a variety of reasons to withdraw it. This runs contrary to Article 104(1) of the Constitution, which does not qualify the right of an aggrieved candidate to challenge the presidential election result once such candidate believes that the declared winner was not validly elected. To withdraw the petition, Kyagulanyi averred in several parts as follows, and I've reproduced them. I'm not going to read them here. The respondents castigated the applicant and his counsel and dismissed the reasons and the applicant had given for withdrawing his petition as having no substance. Contrary to the respondent's assertion, I find the reasons the petition applicant advanced for withdrawing his petition were valid and meritorious. Taking into account those reasons, I find that in the interest of justice in this case, favor an order that each party meets their own costs. There are some other things here I'll skip. I'll now turn to the prayer by the respondents for declaration of first president as the duly elected president. Counsel for the respondents prayed that following the withdrawal of Kyagulanyi's petition, this court should declare that the first respondent was validly elected. Article 104 of the Constitution clearly spells out the role and mandate of this court in cases where it has heard the petition and completed its inquiry, and those where a petition has been withdrawn. Article 104 5 provides as follows. After due inquiry, the Supreme Court may, and B provides declare, I may dismiss the petition, that's A, or declare which candidate was validly elected, or annul the election. There must be a mistake here, because there's article on there's also an article on withdrawal, which is very different from in light which I cite here. In light of these clear provisions, I'm unable to grant the respondent's prayer. The Constitution binds me as a judicial officer and all the respondents and their counsel to respect it as I have done. I guess that's brings me to the end of my. Of course, I have a section before I take leave of this ruling, and there are several reasons. I'll be delivering that ruling tomorrow at 11. Here, working on a duplicate copy, and the ruling I had printed out was confiscated. So Apologies. So I'll deliver my ruling on the Mabiri's application tomorrow. Thank you for your patience and yeah, thanks.